don't know where my highlighter colour's been. Look back.
Very sadly bought spares.
Thank you. If I can't find them. Well, maybe that one works. Actually, you know what? I might use your line one. It's dysfunctional. Thank you.
Yes.
Listen, yes, to let you know, I sent that email. And I checked, and Alan sent it at 1:30 yesterday.
Did she send it to in court support?
I don't know, not on that email. He may have sent you another one.
Yeah. They need to check it really, don't they?
I don't know.
I mean, in court support.
I don't know if I told anybody else.
Not sure if any changes.
I was just checking Alan's email, you know, yesterday. Change of court.
Yeah.
So it went to me, Davis, listing, as in general listing. But that particular email didn't go anywhere else. But whether he sent another email, I don't know. I just sent an email to say, make sure the ushers are aware. I know it's pretty obvious, but she wasn't.
So you sent it to Marion?
Marion, yes I did. Yeah.
Check that your fans are off, please.
Hold on. Is the court ready? Yeah. Sorry.
Are we ready? Is everyone ready? What was?
Yes, Mr. Chairman.
We'll just start with the last question I was asked, which is the chronology for the second judicial review. You will see a summary of that at pages 33 to 34 of the number, where I've set it out in the annex to my skeleton argument. And you'll see some of it.
Sorry, and I've even underlined it, yes. Because the original papers were funny. There was a decision in May 2018 saying they were going to give a decision.
Yep.
And then there's a gap, but there were problems about getting the permit, but that was resolved by the 17th of October, and then the 20th of December was the actual consent order.
Yes, I understand. And the problem, just an outline, we have the luxury of Ms. Hooper here, who was involved at that stage, was that consent order provided following the disposal of the first judicial review action for a decision to be taken within 3 months.
Yeah.
Stage one of that process worked because a May letter was written confirming a grant of ILR. Stage two did not, because the letter accompanying the actual biometric document referred to a grant of discretionary leave to remain for a 5-year period. For 5 years.
Yeah.
Judicial review proceedings were issued on the 7th of September and received on the 10th of September.
Saying it should be ILR, not 5-year DLR.
Yeah.
Yeah.
Applying the 21-day rule, the due time for service was the 1st of October. This is where we do have evidence, page 16 to 17 of the supplementary bundle, but I can just summarize, do make remarks, and you can turn to it if you need to, and summarize that efforts were then made, actually the day after the 21-day time frame, by Mr. Hatton for the claimant to inquire whether it had been received.
I've seen the exchange of correspondence, but you didn't send the acknowledgement of service within 21 days, did you?
No.
Right.
And in fact, what happened is that the tribunal did make a direction abridging the
28 days in effect. It's
Yes.
21. And then what happened when that was abridged? Did you then comply with that?
What the Secretary of State did, no, she did not. But what she did do is so the time was abridged to the 18th of October. A letter was sent on the 25th of October by the appellant's representatives, which confirmed that they had received the requisite permit from social services on the 17th of October 2018. And then the acknowledgement of service confirming that position was not served until the 5th of November 2018.
So you didn't comply with the Kumar arrangements or indeed the specific directions?
With neither of those, yes.
Well, you didn't comply with the rules, you didn't comply with Kumar, and you didn't comply with the specific direction. Apart from that, everything was fine. Okay. In any event...
My Lord, I sense that I would have been very hard-pressed to resist anything but relief and a costs order were that still a live matter before you.
Yeah, but there was a consent order anyway, to the 20th, I think, of December,
Yes.
or thereabouts. Anyway, that went, and she has now got her ILR in the biometric residence permit. Yeah. Okay, thank you very much, Mr. Chairman.
So where we've got to is construction of CPR Rule 29, and you will find that tab 2 of the authorities bundle on page 135. You'll see there are 3 prescriptive limbs. We looked at those earlier. The first, limb 1, says that any person who wishes to take part in proceedings must provide the Upper Tribunal with an acknowledgement of service that is received no later than 20 days after the date on which the Upper Tribunal sent the immigration judicial review proceedings. Second, 29.2 gives some directions as to what the acknowledgement of service should contain. Contain whether the person intends to oppose the application, the grounds of any opposition, or subparagraph A, and any other submission of information which they consider may assist the tribunal. And then 3, the name and address of any other person named. Then 2A, provision for service of other interested parties. And then limb 3 is the provision which provides that a person who is provided with a copy of an application for permission but does not provide an acknowledgement of service to the Upper Tribunal may not take part in the application for permission unless allowed to do so by the Upper Tribunal, but may take part in subsequent proceedings if the application is successful. And you will recall that the construction of the tribunal was that 29.3 does contain a sanction, but it is a sanction which flows from a failure to provide an acknowledgement of service at all. In other words, the provision of a late acknowledgement of service does not trigger the sanction.
What's the sanction for failure to comply with Rule 29(2) capital A, for example? Because little 3 is geared to not providing acknowledgement of service to the Upper Tribunal.
Yes.
The 2 capital A is rather different. So what's the sanction for that?
There isn't a direct sanction specified there, and the risk flowing from failure to comply with that provision is that if, as may well be the case, costs are wasted or incurred as a result of failure to comply with that provision, the respondent is in the ordinary course of proceedings.
I was just wondering if a grant of permission was made, an acknowledgement of service having been received.
Yes.
The acknowledgement of service had not been served upon the applicant, who then thereafter says, had it been served upon me, I would have wished to put in a written reply.
Absolutely.
And so says they could apply to set aside the grant of permission.
I suppose the argument could run from the applicant. Had I received, there are things that I would have said.
Which might have impacted on the grant of permission, and therefore I wish to have it set aside or ask for an oral hearing. Like
yeah, or even if permission is refused, the applicant will say, had I had service of this in time, there were additional things that I would have wanted to say in response, and therefore I now need to apply and reopen the proceedings.
Yes, I mean either way, the applicant.
Yes. The sanction is one.
So you say there is a form of redress one way or another.
Yes.
It's not that set out in sub Rule 3.
No, but there is a powerful means of redress. Fairness, if nothing else, requires as much, and there is costs and reputational consequences upon the respondent for failing to comply with the direction imposed.
And in fact, the rules don't require or permit a reply, so he's not or she's not lost any right under the rules. It's an opportunity that he or she may wish to have had.
Yes, but as a respondent, the argument that that should be overlooked, that opportunity.
Well, you shouldn't overlook it because you're complying with the rules.
And then just to contrast the position.
Just pausing, sorry, I'm just looking at Rule 30, which includes a provision for reconsideration of permission. Which is in very general terms at 3, I think, and 4. So,
yes.
So it might in many cases be possible to achieve practical relief against a failure to comply with Rule 29(2)A by simply renewing and making an appropriate application in costs.
Yes.
In any event, as it were.
Yes, and in terms of what's underlying here, the concern, the incentive and the importance of the respondent complying with this requirement, and the gravity of consequences are, in my submission, clear.
Yeah. Sorry, yes.
Now, it's common ground that when this rule was initially adopted, a consultation had taken place before, and the intention was that it replicate, as you'll see by the days, replicate in broad terms the requirements of CPR 54.9. So it is worth turning to that too, and you'll find it at page 239 of the bundle. The 54.9 is in terms consequence of failure to file and acknowledge of service. And what it does in paragraph 1 is state that where a person served with a claim form has failed to file an acknowledgement of service in accordance with 54.8. 54.8, you'll see if you turn back a page, contains the 21-day time frame. Certain matters follow. And one of the contrasts drawn by the tribunal is that there is not a similar qualification in accordance with Rule 29.1 within Rule 29.3.
Is there any authority for the proposition that it's appropriate in considering the tribunal rules to have regard to the civil procedure rules? Because you would have thought they're meant to be self-contained.
Yes.
There is authority?
No, I'm not aware of any authority.
Although
Yes.
Justice Lane seemed to say it was necessary to have regard, I slightly query that, because it makes it very difficult for practitioners and tribunals that they have to go along to the tribunal and carry a copy of the White Book with them.
Yes. Well, it won't surprise you that my submission would be that the start and end for the construction of the
Rule 29 itself
would ordinarily be the plain wording.
Yeah. But there's no authority which suggests that one should have regard to civil procedure rules in construing the tribunal rules.
No, but I can see an argument running that when one construes the tribunal rules, one looks at the intention. Potentially, one looks at the intention such as it appears from what the rule committee might have said or might have explained prior to that. And where we end up potentially with looking at Rule 55.9 is that the rule committee expressly said we want to replicate in broad terms what is in CPR 54.9. Therefore, we are looking at that.
But it's odd because 54.9 says you can't take part in an oral hearing. There are two ways in which permission can be dealt with, on the papers and at an oral hearing. This expressly says you can't, 54.9, take part at an oral hearing. Can't make oral or written submissions unless allowed to do so. It says nothing about the position for permission on the papers, whereas 29.3, even if it was intended broadly to replicate, it says an application for permission, which does cover both permission on papers and the hearing. So they can't be the same.
Yes, my Lord is one step ahead of me, as before. So in a way, 54.9 takes something away, but it also giveth something. What it takes away is it is in terms directed at the requirement to file the acknowledgement of service within a certain time frame. That is not replicated in 20.9, but in terms of the consequences, and this was something that the tribunal picked up in the KA judgment too, the specific consequence identified is but for an application, the difficulties in not being able to participate at the oral.
It does replicate it in part. They're not entirely different. It's just that may not take part in an application for permission as opposed to a hearing. The 29.3 includes everything in 54.9.1a and more beside.
Yes, and 54.11, I need not take you to, it makes clear that in this context, hearing of a permission is a term of art.
Yes, it means the oral renewal.
Yes.
And also, you say, I think in your skeleton, that the Upper Tribunal is correct to say that there's a difference between 54.9 and 29.3 because it says in accordance with Rule 54.8, and therefore it's dealing with filing within 21 days or failing to file at all. And if you do say that, then you seem to be saying that 29.3 only applies to a situation where there is a complete failure to put any document headed acknowledgement of service, and it doesn't say anything at all about putting in the document, putting it in late.
Yes.
Do you still maintain that submission?
I maintain that, and in fact, I say one gets to the same position under either provision, because under the hypothetical scenario of the late AOS filed under CPR 54.8, there is a specific sanction, but for an application for relief or not being able to participate at the oral hearing, there is not in 54.9 a bar to the court at least looking at the later.
Well, it's silent about the permission application.
Yes.
29.3 is not silent about the permission application, but on your submission, bizarrely, 29.3 is not silent where there's been nothing lodged. And if it's a permission application, the only thing that would be lodged would be the acknowledgement of service. So I find it odd that there's this distinction drawn between the two in 29.3, and I find it very odd that the one time the court can allow participation is when there is the document. So one wonders maybe, I don't know, Mr. Chairman, whether perhaps you could possibly be wrong, and 29.3 is a shorthand reference back to 29.1, and its failure to provide an acknowledgement of service done in such a way that it's received no later than 21 days, either because they don't send it or because they don't do it in time. And if so, then 29.3 applies to both situations. But you say it's not that simple.
Well, I say there is a distinction in the wording. There is not a requirement in 29.3 that the acknowledgement of service be served in a particular time.
54.9 refers to the filing of an acknowledgement of service in accordance with Rule 54.8.
Yes.
Not, be it noted, in accordance with any specific part of 54.8, but 54.8. That is a clear contrast with the language, isn't it, of Rule 29.
Yes.
But as my Lord perhaps observes, taking part in the subsequent proceedings, see Rule 29, is not necessarily the same thing, or maybe the same thing as taking part in a hearing in see Rule 54.9. And there's the further question, which is, even if that person may not take part in a hearing, his acknowledgement of service may nevertheless be taken into consideration by the court.
Yes, but isn't the most sensible construction of that provision that the requirement for taking part or having a voice in the permission process is that you have done the preliminary step of entering your acknowledgement of service. Until you have completed that first duty, it is not open to you to seek to participate in other ways, the most obvious one being where there is a renewed permission hearing, that you turn up. You send your advocate along to make submissions in front of the judge. Alternatively, you provide correspondence, you seek to serve evidence in response. What 29.3 appears to envisage is that before you participate, your voice is heard at the permission, in the permission process, you must comply with the preliminary step of filing your acknowledgement of service.
But what's the logical reason for saying last part of 29.3 that the Upper Tribunal may allow you to take part in an application for permission on papers when you have said nothing, but doesn't allow the Tribunal to allow you to take part by putting in a late acknowledgement of service which says something useful? Why do you say the Tribunal has done that? I know that there's a difference between the words if I put two sheets of paper next to each other, but what was the draftsman of 29.3 thinking about when he said, yeah, I must allow the opportunity for somebody who said nothing to take part, but I'm not going to allow the opportunity for somebody who has said something, albeit late, to take part?
But there would not be any obvious purpose to that. But if one looks at what is actually said in 29.3, in my submission it envisages two steps. One, provision of an acknowledgement of service. And then two, once that is done, participation in the application process for permission.
I'm not with you now. So does this rule apply to somebody who puts an who puts an acknowledgement of service in late, or does it not?
Once you have put in your acknowledgement of service, even if it's late, you've satisfied the first limb, you've put in your application, your acknowledgement of service, and then two, you are allowed to participate. In my submission, it is no more complicated than that. It simply says, if you want to participate, put in your acknowledgement of service.
I thought Mr. Justice Lane had said there's a distinction, and it's only if you haven't put one in at all that 29.3 applies.
Yes.
And if you have put one in but late, 29.3 doesn't apply.
Yes.
And I thought you agreed with that.
Yes.
Then I don't understand what you said to me a minute ago.
29.3 in my submission addresses one particular problem, which is a person seeking to participate in the permission procedure, and the permission consideration, without having done the initial step of filing an acknowledgement of service. And what 29.3 is not at all interested in is when that acknowledgement of service was provided it's in front of the court and the procedure hasn't closed, permission hasn't been determined one way or the other, you are permitted to participate.
So 29.3 does allow you, as an upper tribunal judge, to have regard to a late acknowledgement of service.
Yes.
But it doesn't allow you, well, there's nothing to have regard to if they haven't put one in at all.
Yes. But
That seems to be the reverse of what Mr. Justice Lane was saying, unless I misunderstood him.
But there are ways of seeking to participate in the permission process other than filing an acknowledgement of service.
How?
Turning up at the permission hearing.
No, paper.
Paper.
I'm only dealing with paper.
Yes, sending a letter saying, this is my evidence, I want you to have a look at it.
And they can't do that unless they also do an acknowledgement of service.
Yes.
So you agree that there's a difference, but the other way around. No purpose in separate. So if put in late, can allow under 29.3, the Upper Tribunal can entertain it.
Yes.
And it's a different position in the CPR because it's entirely silent at the paper permission stage as to what the position would be.
Yes, it only says...
It only deals with the hearing.
No, it doesn't even say anything on that. Yes.
But if no AUS, can't put anything else in.
So what you're really saying is this, is it? Which may or may not be right. Leave aside CPR Rule 54.8, 54.9. When we're dealing with Rule 29 of the Tribunal Procedure Rules, and in particular Rule 29.3, the words mean what they say.
Yes.
Full stop.
Full stop. And there was a reason why I set out as broadly as I did the various purposes that the acknowledgement of service serves, and why it is in the interest of all the stakeholders, provided this document is there, for it to be available for consideration by the court. And if one bears that purpose in mind, then in my submission it is not at all surprising that whether we proceed through the CPR 54 route, or whether we proceed through the Rule 29 route, we end up at a position where at core, at the very least, once this document is available, the judge is entitled to look at it.
If there's the uniting point you submit for these two rules in different places is that if there is an acknowledgement of service before a decision is made on permission, it may be taken into account.
Yes.
But must be, in any event, if filed within time.
Yes.
That's it in a sentence, isn't it?
Yes.
But to be difficult about it, the reason why you can say yes to that in tribunal rules is because of the words allow, but there's nothing in CPR 54 that deals with the paper permission stage, but you say it must be what's contemplated, because there's nothing to stop it, and all the CPR does is deal specifically with the oral hearing, where there might be bigger questions about can somebody turn up or not.
Yes.
Is that it?
That is it. And one submission that may be made against me on that under the CPR is that the CPR contains specific provisions which deal with defaults, 3.8 and 3.9. They are not found in the Upper Tribunal rules. And certainly, where one has a situation where the CPR rule itself contains a sanction, the courts ordinarily proceed through the route that if you haven't complied with the provision, the CPR automatic sanction bites. Your only route to redeeming yourself, to saving the position, is through CPR 3.8, 3.9.
in the light of this exchange, I'm getting increasingly puzzled in Rule 29.3 by the words "may not take part in." And that sort of makes sense if you're contemplating an oral hearing, but that's not the norm. And so what does it mean, may not take part in? Slightly odd wording.
It is rather
And
broad.
it would fit if you were contemplating an oral hearing, but we're not normally contemplating an oral hearing.
One way of reading that is that it's implicitly directed at the prospect of an oral hearing. But another way, as I explained a moment ago, is that parties may well, particularly if time is tight, and they're already in default, they may well wish to take part at the permission stage in various ways. They may seek to file a witness statement, they may seek to file documents, they may send a letter to the court, they may say, take this point into account.
Well, I have had cases like that, and then there is a big question as to whether you allow these letters to stand, because it's difficult for other parties to know what the status is. There is some purpose in having a formal document, even if the letter is just stapled to the back. But that's taking formality to a new level.
Well, that is not my submission that that's taking formality to a new level. And I've set out the importance of the acknowledgement of service. And lots of things are debatable in this case, but one thing is clear, and that is that under Rule 29.3 in the Tribunal, until you have taken this important procedural step and you filed your acknowledgement of service, you may not take part in the
And that
in the
would
way
mean
described by my
if at paper stage you hadn't provided an acknowledgement of service, you couldn't, as it were, at the last minute, the day before the matter was going before the judge for determination on the papers, put in a letter or a skeleton argument or other document to engage in the process, take part in it in that way.
Well, the presumption is no under 29.3, but you will recall the wording towards the end.
Of course, unless the tribunal says, I am going to take account of that.
Yes, which then brings us back to one rule we looked at already, which is Rule 7.
And your submission is that words mean what they say, and the words may not take part in are broadly and even colloquially expressed to encompass all forms of taking part.
Yes.
But in fact, you could allow under this rule, if you're still at the paper stage, you could allow a late AOS, a witness statement, or indeed a letter under this. You don't need to have an acknowledgement of service for 29.3 to apply. Why do you say you have to have that? A person who is provided with a copy of the application but does not provide an acknowledgement of service to the Upper Tribunal may not take part in the application for permission. If he has provided an acknowledgement of service but it's late, he may be allowed to do so. Or are you saying that, I'm still uncertain as to what you say 29.3 applies to. Is the rule applicable at all to a state of affairs where prior to the decision on permission being granted or taken, an acknowledgement of service is filed a bit late?
If that is the state of affairs, then the sanction, the consequences identified in 29.3 do not bite.
Because you've allowed it, or because you don't even have to allow it? You're dodging that issue with the greatest respect.
Yes, I say under either route. This brings me back to why I say there are some aspects of this which are academic.
Speaking for myself, I would have thought, trying to make sense of the words may not take part in, I would have thought, trying to make sense of it all, that would extend to Secretary of State putting in an acknowledgement of service late. He's trying to take part in the application. The question then is whether she should be allowed to do so.
Yes.
Isn't that the way the rule naturally read works?
I say one is that,
and it may well be the tribunal judge will look at the acknowledgement of service late, and in which case has impliedly allowed it.
but this is where we are likely to end up at the same position eventually. But to be fair to the appeal and the way that it's been brought, it's quite clear that the tribunal read this provision as implicitly not biting where the acknowledgement of
Yeah, but
service.
they may be wrong, actually.
Well, they may be right for the wrong reasons.
But it won't surprise you that I'm defending that reading of it, and I say the reason why that reading is correct is because the tribunal rules could have, as with CPR 54, could have said specifically acknowledgement of service within the
The reason why Mr. Justice Lane appeared to think the rule meant that was because the words in accordance with the rule wasn't there.
Yes.
Now, if you forget all about the CPR rules and you pick this document up and you're an ordinary English reader, the first thing you need to read is 29.1, which says, and wishes to take part in the proceedings must provide to the Upper Tribunal an acknowledgement of service, so that it's received no later than 21 days. You've got to do the acknowledgement of service and make sure they get it within 21 days. When you get down to 24.9.3, that might be seen as a shorthand reference back and as covering a situation where you have provided an acknowledgement of service, but it hasn't been received within 21 days, it was late, or hasn't provided an acknowledgement of service at all, so they haven't got it within 21 days, but they've sent in a letter or a witness statement, and the tribunal is going to allow them to take part, if it thinks it's appropriate to do so, with a late acknowledgement of service or a letter. And it would be bizarre if they could take account of a letter but not an acknowledgement of service, because you scratch the word acknowledgement of service out and put this is a letter at the top. It's meaningless, isn't it? Doesn't it just refer back and cover both non-delivery and late delivery?
No.
No, it doesn't.
In my submission, had that been the intention, it would have been a very simple thing to insert that wording into the provision. That's one. And two, there are very good reasons.
So if it's late delivery, you don't need any kind of allowance at all because you've now filed an acknowledgement of service and it's out of time, but you've got to have regard to it. You're not within 29.3 at all.
No.
If you fail to provide it at all and send in a letter or a witness statement, that's when you're in 29.3.
That's when you're in 29.
What's the rationale for that?
The rationale is that for all the reasons I gave when I started my submissions, it is in everybody's interest that once the acknowledgement of service is there and has been provided, that at this preliminary stage, at permission, in deciding whether the case is arguable or not, that is a document that's available.
No, but if you do notionally write in the words, it does not provide acknowledgement of service up to tribunal, and then notionally write in the words pursuant to Rule 29.1, you can still achieve that just outcome because of the allowance.
Yes.
So you can still do it.
You can.
The point is you then perhaps have the valuable backup of a judicial oversight taking into account the fact that it wasn't done in time. And no doubt all the considerations say how advantageous it is will weigh on the tribunal's mind, and they may well, probably often will say, we are going to have regard to the acknowledgement of service. But it also enables the tribunal judge to say, no, this is so outrageously late, I'm not going to. What's wrong with that?
But that is not in terms of what's provided for here.
No, it's not in terms of, but I'm saying if you notionally write in accordance with Rule 29.1,
Yep.
that's where you get to. And
Yes.
you say that judges shouldn't engage in creative interpretation of this kind.
There's a reason why I say we end up at the same position on this. Because of the wider...
Yes.
Because of the wider case management powers.
Yes, I can see that.
Even if you're with me on my reading and the tribunal's
yes.
reading, one can still end up at the position where the tribunal says, okay, you're not formally in 29.3 territory, but this is so outrageously late, and this bears so little resemblance to the requirements of an acknowledgement of service as set out. 29.2, I will not have regard to this, and I will not allow you to participate applying the general case management powers of the tribunal.
The only advantage of your approach to say that if you have got one in late, you're not into 29.3 and the rules are silent and there's nothing to stop a judge looking at it, is that is the express position under 54, because there's nothing about late service of the acknowledgement of services or late filing of acknowledgement of services. So you'd say it's the same position in both. There is no prohibition on looking at it.
There is to that extent. consistency, and at the risk of sounding like a scratch record, I say there are reasons why there is that consistency and that assumption that once this document is available at the permission stage, it is at least looked at. Whichever route you take, whether you take my route of saying, even if it's late, the 29.3 sanction doesn't apply, whether you take the route explored
But what permits them to look at it if it's late? Because 29.1 says it's got to be received no later than 21 days. And on your analysis, 29.3 doesn't apply. So what does allow them to look at it if it's late?
where the implication is that a document filed, even a document filed late, is not for that reason alone a nullity. Rule 3 provides as much. And there's nothing in my submission that's in Rule 29 that says that an acknowledgement of service quite otherwise than in accordance with Rule 29.1 is thereby deprived of the character of being an acknowledgement of service. The acknowledgement of service characteristics are 29.2 in terms of the contents that are required to be in it and in terms of the case law contents that are required. But it could have been, and it was not done, to confine acknowledgement of service in 29.3 to an acknowledgement of service served within the time frame of 29.1.
Because it's more logical. I mean, the wording, sorry, this is the last quote, is, wishes to take part in proceedings must provide to the tribunal an acknowledgement of service so that it's received. So that it's received is just a description of how it's provided. And 29.3 says must provide an acknowledgement of service. Question, how do you do that? You send it to the tribunal so that it's received no later than 21 days. That seems more capable of covering 29.1 without having to read in words, but you say no.
I say
no.
That is the wording, and that is a literal reading of it.
Right.
And I say...
So all the huffing and puffing in Kumar really rather becomes irrelevant, doesn't it?
Yes.
I mean, 29.1 is just a mild inconvenience to the Secretary of State, because it doesn't matter if they don't have regard to time limits, because they can always, as long as they put it in before permission is granted, it will be considered. I just find that slightly an unlikely result.
Yes, and it isn't, for the following two reasons, the result that occurs here. Consequence 1, if you have not filed your acknowledgement of service...
No, you run the risk. You got the risk.
Of permission?
Yes.
Consequence 2, if the decision is taken, whether it be taken in your favour or against you, there are potential cost consequences coming your way and potential reputational consequences if a matter hasn't been set out, which should have been. And the two obvious consequences considered by the tribunal in Kumar were: 1, if it's not certified totally without merit, therefore it goes to oral permission stage, you're liable to bear the cost of that. And 2, if permission is granted, in the ordinary course of events, you are liable for the cost up to the detailed ground stage.
I intend no disrespect your client, but I've been doing these cases for many years now, Mr. Taman, and I don't think reputational damage arising from late compliance with the rules seems to feature very much.
You will have seen the witness statements, or you will have seen them
yes.
summarised in these proceedings
Yes.
in terms of the efforts taken to.
Yes, I'm just trying to enter the real world. Right. Anyway, but I understand your point about cost, and I understand, of course, your point about, speaking for myself, you run the risk.
You do run the risk.
The permission may be granted if you sit on it and acknowledge and say you run the risk. Permission is granted.
Yes.
But if you were against me on that, where do we end up under the tribunal rules? We proceed to Rule 7.
Same.
Yes. And one challenge, one gauntlet that was put down by the tribunal in Kumar, was put down again to junior counsel in these proceedings, is give a practical example where it would be in the interest of justice for a court who has received an acknowledgement of service in order at least to look at that before the decision on permission is taken.
So let me understand what you're saying now, just so I'm clear. If you're right about 29.3 being limited to a complete absence of acknowledgement of service, and if we're dealing with put in time, one option is to say they can look at it, there's nothing to stop them looking at it. But that, if that is wrong, you're saying the other way in which an upper tribunal can permit the entertaining of a late acknowledgement of service is 7.2a.
Yes.
That's it, right, okay?
Yep.
Because there's nothing like that, is there, in CPR 54 or the CPR rules?
Well, I
CPR
suppose
54 does say,
Or is there something in 25 or something?
well, is there not provision in? Do you not go back to CPR 3.1?
yes, and
No,
54.9.2,
There must be something.
You'll be wrong.
59.1a, as the individual then who hasn't complied may not take part in a hearing, so permission should be
But
given.
this is paper permission. I'm not interested in the hearing. The hearing is dealt with.
Yeah.
This is paper permission. It is whether a judge sitting in her chambers and is brought as she's about to put pen on paper for the order and she's told there is an acknowledgement of service. Can she say, I can look at it, there's nothing to stop me? Or must she say, Rule 3.1, I'm hereby waiving
3.1.2, isn't it?
the 312.
A. Is that right?
There's two ways of analysing that. One is there's a specific sanction provided in 54.9 1 for failure to meet the deadline requirement. That is that your participation at the oral hearing is in jeopardy. Therefore, it isn't necessary to imply an additional one for that particular default. There is an automatic consequences already within the CPR. But again, as with the tribunal rules, if you're against me on that, if you decide that must a fortiori be a sanction, a consequence, then I say yes, through the auspices of the general case management powers enjoyed by the court is entitled to waive the time requirement.
Well, 7A is waive the requirement. 3.1.2 is extend or shorten the time for compliance. And this goes back to what Mr. Eck was saying about Singh, and that's why Mr. Justice Hickenbottom then was wanted an extension of time, and why she says that you must have an extension of time. But it's different under the rules, procedure rules, it seems. Whichever way you look at it.
Yes, and that there are those differences, and that's one of the points you'll recall which was picked up by the tribunal below.
Sorry, Mr. Chairman, my fault, I'm getting lost. Why isn't it sufficient for your purpose? And this alternative scenario is simply to focus on the words unless allowed to do so.
Yes.
Well, why do we need to, and Rule 7.2a is there, but why can't you say, well, actually just within the body of Rule 29 itself, the requisite power is conferred
Yes.
to allow, and you would say allow is a broad word.
It's an inherent and specific discretion.
Yes.
But you say only when there's been nothing. As I understand your
Well, we're now in your alternative argument, I think, aren't we?
Oh, yeah.
Well, I think I'm being given three options. One is the reading by the tribunal.
You probably think you're getting no options at all at the moment, but anyway.
One is the tribunal's reading. That once you've provided your acknowledgement in, albeit late, the sanction doesn't bite. Two is that even if it does bite, there is express provision within 29.3 for the court directing otherwise, hence the wording. And three is through the route of Rule 7.
3 was the root of?
Rule 7.
Rule 7. And which do you say is right as opposed to the smorgasbord of options? Just remind me what the Secretary of State says the rules mean.
You won't be surprised that my position is, as the tribunal's position was,
One.
yeah, it's option 1. That is the construction. Are there any more questions on that? And I think getting a very thorough hearing on that
No,
aspect.
I think we're done on that.
If we then move to the next limb, which is
Probably
the
thought it was the barristers who did the cross-examining.
I'm in front of 3 experienced cross-examiners, I can tell. So on the virus, which is the next limb, I say it is informative to bear in mind the issues on construction, to consider what the tribunal actually was doing, was intending to do in the Kumar. And I say the useful starting point to that is Kumar itself and what was said of paragraphs 34 onwards. And you'll find Kumar page 647. And I say the first paragraph to bear in mind is paragraph 34, where the tribunal made clear, I'm on page 664, that given the backlog of cases before the tribunal, it was not at that stage in a position, in the general run of things, to look at cases within a 6-week period. And therefore the Secretary of State filing for acknowledgment of service within a 6-week period did not in practice entail any further delay. And then linked to that state of affairs, we turn back to paragraph 28. There was a question as to what point would be served by the Secretary of State making applications of extensions of time for failure to comply with the 21-day time frame routinely. And the tribunal pointed out, apart from requiring payment of the requisite fee, such an application requires a judicial response, albeit that the time needed for such a response is individually not great. Sheer number of applications means a significant amount of judicial and administrative time. The Chamber is being devoted to dealing with second and subsequent applications for extension of time. In that context, that proposal was made. A notice was given to the Secretary of State, paragraph 34. The tribunal was in a position that, unless treated urgently, it would not routinely look at applications earlier than 6 weeks by the Secretary of State, and made some provisions for urgent applications to be dealt with. And in paragraph 40, in accepting the proposal, the Secretary of State made clear that she would not regard the proposal, if implemented, as dispensing with her obligation to serve the AOS as soon as she can do so, wherever possible, within the Rule 29.1 period.
So do you submit that when one reads the whole decision, it's clear that what is being done is to build on the provisions and to assume that they are as they are, not actually to interfere with them, but to describe the way in which those provisions will be operated as a norm?
Yes.
So it's descriptive rather than intrusive.
But what the tribunal was doing was giving the Secretary of State notice that it wasn't in a position to look at matters within a 6-week period, and that therefore no practical or no good purpose would be served in making the applications that she had been making within the requisite period to obtain what following thing became something of a routine approval stamp process in order to obtain that first application, that first extension. But then the tribunal made clear, as the court had done in Singh, that if you still hadn't got your house in order by the 42-day stage, it would require rigorous and case-specific reasons as to why a further application should be necessary.
So this isn't an indulgence for the Secretary of State. On your analysis, it is the tribunal saying we can't cope. We already have too many cases. You needn't worry about them being decided before 42 days. That's just not going to happen. And because we accept Mr. Towan's interpretation, if you yourself don't need the 21 days, there's no consequence that follows because we'll still look at it anyway. That's what this means.
I don't think the tribunal in Kumar had the debate we have just had about 29.3 in mind. Certainly
That
doesn't
is the
feature.
logic of it. If
Yes.
your interpretation of the rules is correct,
Yes.
that is the outcome of this. It's not so much we're allowing you to put in late and we look at it, because if it was put in late, they would look at it anyway, and indeed on your analysis had to look at it anyway. And the only difference is the comfort in knowing that failing to get it in within 42 weeks is not going to be a problem, because the tribunal isn't going to be looking at them within 42 weeks unless asked to do so.
Yes.
42 days.
But the other side says this was in effect to generate a new rule, because it was in effect to indicate that the tribunal's discretion was de facto restricted or fettered, if you will, albeit for administrative reasons. So the other side says, well, look at the real effect of this. It is to generate a different rule. That's effectively what it's submitted.
Yes. I mean, there are.
That's the case you have to meet on Kumar.
Yes. I mean, as my Lord Justice Lewis says, if I'm right on 29.3 in the construction, the problem simply doesn't arise, because by definition, the late application falls to be taken into account. But the Secretary of State still gains something, because the Secretary of State then knows, until notified to the contrary, this is the caseload of the tribunal, and therefore the 29.1 risk that the decision will be taken without having heard from me, with all the consequences that arise from that. That spectre at least has been lifted by the notification that that's where the tribunal is.
What he gains is a sense of relief from risk.
Yes.
Well, let's look at the consequences of that. Suppose, as it were, contrary to this indication, if I can call it that, the tribunal goes ahead and determines an application for permission after 30 days. The Secretary of State turns around and says, but that's directly contrary to what you said in Kumar. Because in Kumar you gave us the assurance that for administrative reasons you wouldn't be able to get to our AOS until, or to the application for permission until after 42 days. And now you've gone ahead and granted permission. It's almost akin to a breach of legitimate expectation or some such legal concept.
That is the benefit, although...
And that in a sense is another way of looking at the other side's case.
Yes. Although that scenario presumes that there hasn't been an application for urgent consideration.
Oh yes.
But certainly, if it comes out of the blue after 30 days, the Secretary of State could and probably would have said,
yes,
what you've just said in Kumar, 42 days, before 42 days, you will not routinely get.
Well, were there such cases?
Not that I'm aware of.
Actually, the tribunal is binding itself not to decide within 42 days, even if it could, precisely so the Secretary of State will have 42 days.
But it's binding itself only this far, to say that if we end up in a position where we're looking at our cases before 42 days because our backlog is cleared, or for whatever other reason, you can expect to hear from us.
Yes, but it's not qualified in that way. Yeah. It's not, as I read it, tell me if I'm wrong, it's not qualified by the statement so long as our present backlog persists. Is it, or is it?
Paragraph 70.
70?
Paragraph 70.
Yes, but that implies that there's a formal review to be undertaken, not that it will be done ad hoc, as and when the tribunal decides as it were, privately for itself, that the backlog has been sufficiently addressed.
That is true, but if we are analysing this in terms of legitimate expectations, what the Secretary of State actually gains here, there could and would have been no complaint had the backlog been cleared and the tribunal notified the Secretary of State, our backlog is now dissipated. Now just you that is preventing us from looking at these cases. Therefore, we will move to a system whereby, unless you apply, we will be looking at them earlier. There could not have been a complaint from the Secretary of State. But my lord is right. Paragraph 70 in terms is tied to the particularly temporary difficulty that the Secretary of State is facing.
Yeah, well, the other side's entitled to say, and perhaps you ought to address this. There's no indication here that the tribunal will suspend this practice or approach at a moment of its own choosing, which will not be declared to parties. What is held out at 70 is rather the antithesis of that, which is that there will be a review, albeit an active one.
Yes.
And the other side might submit that that rather reinforces its argument on Kumar. What do you say to that?
When I say if one analyses it in terms of the Bovale case, which you were taken to earlier, what is clear from paragraph 70 is that the Kumar arrangements were and were only intended to be a temporary response.
But how can that affect vires? You know, if you do something unlawful, if you beat somebody for a few months but promise to stop afterwards, it's still assault. Well, it's a bad example. But
The question is this.
it'll stop soon, isn't
Yes.
it an answer to legality?
What I say, how this cuts in terms of legality and in terms of the, perhaps it'll assist if we look at Bovale in a moment, but I say in summary, was the tribunal the wrong side of the Bovale line here? Was it purporting to redraft the rules? Was it purporting to recast them in general terms? Or, and this is where we're on the case management side in my submission, was it purporting to make specific arrangements for a particular cohort of cases? And in my submission, what paragraph 70 makes clear is that the pinnacle of the tribunal's ambition was to make a particular temporary provision for an individual cohort of cases, that is, those caught up in the backlog that was then experienced both by the tribunal and by the Secretary of State. And I say that is a very long way from the purported rewrite of Part A in the Section 287 context of Mr. Justice Collins.
Well, you say that the whole exercise in Kumar is predicated on the rules being what they are.
Yes.
Not to reconfigure the rules or to purport to do so. Contrast Bovale.
Yes. And you have not only the express confirmation.
Your submission would be then that actually Kumar, there wouldn't be any need for Kumar unless the rules were what they are.
Yes.
And this is not in anywhere near Bovale territory, because the presumption, if you like, or the assumption that underlying the approach is that the rules are as they are. This is merely a pragmatic indication to parties as to what they can reasonably expect.
Yes.
That's your argument, isn't it?
Yes. See the confirmation of the Secretary of State. See what is said at paragraph 70. And it is relevant, and this is a point discussed by my lords this morning. It is relevant to the extent to which this particular accommodation for this particular cohort derogates, if at all, from what would happen in the ordinary course of events. This was not a state of affairs which can be compared with Bovale, where a requirement to file evidence was suddenly imposed, where there was none, where the rules of Part 8 were effectively rewritten to be...
Well, as I understand it from Bovale or Bovale, Mr. Justice Collins actually directed in a way which was contrary to what
Yes.
the Part 8 said.
Yes, and said in terms.
It said in terms.
Yes,
You're not required to. And he said, well, actually, you are.
yes.
And you said that's not this case at all.
No. I say this case recognizes, reinforces the importance of the acknowledgement of service, the importance of the time frame, and makes a particular arrangement for a particular cohort, a temporary period, intended to be temporary, in the term suggested. So even if I'm wrong on the construction aspect, in my submission there is nothing in Beauvale, I trust my Lord's pronunciation more than mine on that, there's nothing in Beauvale which precludes the very limited arrangements made. And just as there is something for everyone in the acknowledgement of service document, there was something for everyone in this arrangement, because it made sure that the court judicial and administrative resources were not diverted by making these applications, by determining these applications, which in that period were liable to be rubber stamped, saved diversion of Secretary of State resources. And that also meant, because the administrative and judicial resources of the court weren't diverted by dealing with applications in four-figure numbers or extensions, and there were more judicial and administrative resources available for dealing with the backlog and for dealing with the claims. Just so I've said my response, I won't take you to it. Two cases that are relied upon against me are Sayers and Salford Estates. They're both in the bundle, as I've said in the skeleton argument. There are circumstances under the CPR where your entitlement to bring proceedings, your entitlement to appeal, is contingent upon doing a certain thing within a certain time. Filing your appellant's notice is one, filing your respondent's notice is another. And it's well established, the two cases show, that applications for extensions of time under those provisions fall to be determined in accordance with the Mitchell principles. But for the reasons I've outlined, that is not an approach which is applicable or appropriate in the context of whether the court should have regard to the acknowledgement of service. And I say that is because regard to that document at that stage in the particular permission process is in the interest of justice and for the reasons I've set out in everybody's interest. That is all I had to say on Kumar and virus.
Right.
Dealing then with the issue of whether this is academic or not.
Yeah.
I can deal with that relatively briefly. The Kumar arrangements themselves came to an end at the end of 2019.
Well, 2018, was it 1st of January 2019? Yes. Is that right?
Let me just, yes, at the end of 2018.
With effect from the 1st of January 2019.
Yeah.
Yes. Sorry to be
No,
difficult. Yes.
that is important. As the Vice President said in refusing permission, they are unlikely to recur. But I do not need to go that far. I simply say there's no present indication that there is a similar case before this court which requires hypothetical determination at this stage.
And it doesn't affect KA's case, it's been determined.
No. That then leaves the Rule 29 construction aspect. And the court may have detected where I'm headed with this. What I say is that whichever route one takes, be it Rule 29.3, be it CPR 54.9, be it Rule 29.3, unless, the point by my Lord Justice Davis, be it Rule 29.3 coupled with Rule 7, one ends up at the same position. And that is that it is overwhelmingly likely to be in the interest of justice for a court to look at an acknowledgement of service.
Yeah, but the question on academic is, should we rule on it or should we leave it to somebody else
Yes.
to rule on? So, a different
Yes.
point of academic.
You're again one step ahead of me.
Oh,
The
sorry.
reason I say that is of interest in determining whether this is academic or not is that nobody has been able to think of or provide a hypothetical scenario where it would be appropriate for the court.
So you say we can say that it's academic because you're bound to win one way or another. Is that the submission?
It doesn't arise in this case,
Yeah.
and in terms of, my lords will know the threshold that is imposed for determining cases where there isn't a list between the parties. And here we are being asked to deal with an academic, in my submission, issue in the case, and an issue which, whether the route is taken, suggested that the various options are taken, one ends up at the same result, and that is,
But that's if one of your three routes is right. But there is
Yes.
option 4, which is that Miss Naik is right. She could be right.
yes.
And are you saying it's academic for us to decide whether Miss Naik is right rather than one of your three options? I can see it's academic as between your three, but there is Miss Naik.
In my submission, at the very lowest, there isn't an indication that there are lots of cases in front of this court where this particular problem arises, where it's being said, the court erred in having regard to the acknowledgement of service filed late. The court should not have done that. It was against the interest of justice. It is more
But
appropriate.
it's not too difficult to foresee that this kind of situation will arise in the future. And isn't there potentially some advantage in the appellate court ruling on the matter so that parties know where they stand? Otherwise, people look at the Upper Tribunal decision and they'll either say we agree with it, how wonderful it is, or they'll say we disagree with it, it's utterly wrong. So it would still be potentially left open. Is that not an advantage now the two of you are here arguing the point? This court just ruling so people know where they stand hereafter.
Well, I foresaw that this difficulty was going to arise, particularly as I'm making the submission when I'm making it. But,
It's not the same as your Kumar point at all.
no.
No.
But, no, it isn't. There are two separate points.
Quite different.
Yes, but in my submission, it is of advantage, at least conventionally, to consider this type of issue, this kind of point, in a case where the actual problem has arisen.
Where the facts are clearly identified.
Where it actually, yes, and where it actually matters.
Yes,
But
but
it
I'm not
did
sure.
arise, on the facts of this case. It's been resolved. So in terms of having concrete facts, we know exactly what happened in this case. And the question is whether on those facts, Rule 29 means one of your three options or Miss Naik's options. And if we don't decide it, there will be the Upper Tribunal decision in place that people will probably look to, even if not binding. And what if we think that might be wrong? And indeed, you've given three interpretations.
Well, in terms of how it matters in this case, you will have detected that particularly the virus aspect emerged for the first time on the 14th of May, about a week before the hearing. The Kumar arrangements had been in place for some time. These proceedings had proceeded in some time. All the parties recognized that this was an unusual arrangement, which needed to be brought and was brought to an end soon afterwards. So in terms of how much of that live issue, how much of that live dispute is still alive today, the Secretary of State is now very firmly on jeopardy if she misses.
Sorry, I didn't hear what you said.
The Secretary of State is now very firmly on jeopardy if she misses the 21-day.
But no, she doesn't know, because she doesn't know whether Miss Naik is going to succeed or whether she'll win on one of your three options. She doesn't know what to do. She doesn't know whether on day 20 she must put in an application for an extension of time, as Miss Naik says, or whether she should trust to fate and you'll win on one of your three.
And if she doesn't, if she doesn't put the application in on time, she is at risk of the tribunal making a decision.
On permission, yes.
Submission. She's at risk of all the cost consequences that flow from that. And I say, in those circumstances, in terms of deciding post-Kumar arrangements, whether this is still a live issue of sufficient importance for this court to rule upon it now that it's become hypothetical.
This is Rule 29 we're talking about, not Kumar.
Yes.
I mean, Rule 29 is of wide application in the tribunals. You have not submitted to us, I don't think, that its interpretation is just so obvious that it really doesn't need to be determined by a court. It's not one of those statutory provisions that is just lucidly clear in its own terms. It doesn't require such construction. And the question really resolves, therefore, whether in practical terms the tribunal's world, as it were, out there would benefit from this court resolving, albeit that there is not, as it were, an active dispute between the parties any longer, what that provision of the rules actually means.
Yes.
And that's what the other side is contending for, at least in this part of its appeal. And we're on 29.3, mind you, not Kumar, when we say that.
Yes. And I say, I won't labour the point, I say it's difficult to see where post-Kumar this particular issue will cause difficulties in practice, because post-Kumar there are powerful other incentives.
Are there any practical reasons why this court lacks either submissions or factual material to enable it to determine Rule 29 such that we ought not to deal with it if we think it would be desirable to do so?
No.
So there's nothing that would make our decision suspect?
No.
So we've had Miss Knight, Queen's Counsel, arguing the case for the appellant. We've had you, on behalf of the respondent, arguing the case for the Secretary of State. And you say, at the end of the day, we should do nothing.
Well, you recall...
No, the order which this hearing is taken. But
yes.
I know it's not the perception of every litigant, but this court is here to try and help.
Yes.
I know not every litigant believes that, but we do try. And would it not be of some help if we could give a ruling on, at least on the Rule 29 point? I understand the point about Kumar myself. I understand about Kumar entirely. But I don't know whether it helps anyone if we just don't deal with it.
Well, as you point out, there are two difficulties I have. One is, I spent the day taking up your time arguing the points. And you've been very patient in listening to me on it. The second is that I've said to date it's entirely hypothetical because, of course, one looks at this document. I think we had the emergence of an example where it might happen from my Lord Justice Lewis, which is the scenario where the conduct is just so egregious that even though you have your acknowledgement of service, you say, no, it's just too late, you have forfeited that right. So for the first time in this hearing, we do have a hypothetical scenario where the question might arise seriously for the court to say, I've got the acknowledgement and I'm not looking at it. I've said what I've said about the likelihood, the practicalities of that, but I entirely realise we've taken up your time to argue it and you will make a decision on whether this is academic or not, or should be entertained, having regard to the time.
You're entitled to the point that it's an important principle that the courts try not to deal with academic yes.
Let me check if there's anything else from you.
Not from me. No, not from us.
Nothing from behind me, then thank you very much.
Thank you very much, Mr. Turman. Ms. Knight.
I just have a couple of points in reply, hopefully not take too long. Just to come back to the 29.3 construction, the way the tribunal dealt with that in Kumar, at 68 in the guidance at paragraph 4, was to say if the Secretary of State doesn't comply with the 21-day time limit, she will be required to file an application for an extension of time. So,
where is that in Kumar?
So if we look at Kumar at paragraph 68, so it's tab 25 of what is Kumar. 68, these are the summary of the new arrangements.
Yeah.
We summarised them. So let's just dispose of 1, 2 and 3. In view of the paragraphs 1 and 2 above, the tribunal will not consider it necessary for the Secretary of State to apply for an extension of time of the 21-day time limit in Rule 29.1 unless she considers she's unable to file an airbest before the expiry of 6 weeks. So the tribunal's own approach was there has to be an application for an extension of time in certain circumstances.
Yes, because if they get past 6 weeks, she runs the risk that the tribunal decides it.
But they didn't. There was no suggestion that my reading of that, or certainly one reading of that, is that she may want to do that, but there's a provision here that allows the Secretary of State to make an application for an extension of time, and one reading of that is that's consistent with 29.3. I think there was a suggestion. My understanding from Mr. Tomum's submission was that the Secretary of State didn't necessarily have to do anything at all. And of course, she would run the risk if she didn't do anything. But the Kumar arrangement suggests that you're applying to extend a time limit. And it's gone from 21 to 42. That's my reading of my submission as to how what the tribunal were doing, and that's how it's described: an application to extend the time limit. I agree with an ambition to avoid running the risk, but it is described in those terms, if I can say it in that way. The second point in relation to
It's picked up 68.7, you see, is the point. She does go on to say, except as provided above, blah, 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 the parties can expect the tribunal to consider the judicial review application at any time after the expiry of the 6-week period. So it's not possible. I understand the tribunals use the words, but the argument has moved on a bit beyond that, and it's the context, really.
My lord, I can see that, but just the opening part of 68.7 is except as provided for in paragraph 2 above, where time is extended in response to an application by the Secretary of State for an extension of time. So there certainly is a contemplation that there could be an extension of time application. That's consistent with the admin court guide. I appreciate we're dealing with a different set of rules, with the retrospective application, which is at, just for the reference, Supplementary Authorities Bundle, tab 10, paragraph 7.2.2. But there are two practice statements from the former senior president, which are in the supplementary bundle, which I just wanted to take the court's attention to, which are tabs 5 and tab 7, which both suggest, again, I would say, if I take you to tab 5 of the supplementary authorities bundle, that. So this is a practice statement made by Sir Jeremy Sullivan, 26th of April 2013, and then the subsequent one in October, which sets out the practice statement. This is pursuant to supplementing the Senior President's practice direction at paragraph 1.1, referring to application, this is at 2.1, applications for permission to bring proceedings, whether commenced in the High Court or the Upper Tribunal, are submitted to the Admin Court Office. Consideration of permission 2.2, they won't be considered before the time limit for lodging an acknowledgement service has expired, footnote 2, 21 days, unless the respondent has indicated no acknowledgement service has been lodged or has asked for urgent consideration, and then the alternative about urgent interim relief. And the same, you see the same point made at tab 7, the next practice statement, again by Sir Jeremy Sullivan, former senior president, which, so the practice, again, paragraph 1.1, the practice statement supplementing the senior president's practice direction, 2.1 dealing with lodging applications, either to the High Court, which fall, or within the, because the transfer order, just to be clear, and again we put the transfer order in section and the provisions of the Senior Courts Act, but these judicial reviews are all transferred to the chamber in the Upper Tribunal by order, by the Lord Chief Justice's direction, and so they are effectively High Court applications that then are transferred. And that's why the senior president in my submission has made these this practice statement, which applied to both forums. Considering permission, this is at 2.2, the application for permission will not be considered before the time for lodging the AFS has expired, back to 29.1. And then 2.3, an application for extension of time to lodge the application will be determined at the same time as the application for permission, and permission will not be granted unless an extension of time is allowed. That's and then 20.
That's for the claimant's application for permission. That's nothing to do with the OS, is it?
I think that must be right. Yes, and then 2.4. Oh yeah, sorry. So yeah, sorry. I apologise. I was those are two separate points. But the provision is at 2.2 that the application for permission won't be considered until the time for lodging has expired. So that's certainly the practice statement in two places by the senior president suggests a time limit in 229.
But it's saying that it's spelling out the implication that because you've got 21 days, it won't be decided afterwards. So how does it help with the problem that we've got?
I mean, perhaps I've already made those points, but just to say, we say that that's why 29.3 should be read with 29.1, and the further support for that is necessary is in that practice statement. The only other points, I don't think I need to address the academic point unless the court wishes to hear from me further. Suggested it was an unusual arrangement and needed to be brought to an end. Now that again, that all doesn't undermine the question of the importance of this court determining under what powers they were made. And it does have consequences beyond costs because parties need to know where they stand. That's what we say in relation to timing, as to when matters are going to be determined, but going to be responded to by the Secretary of State and the court. So yes, and I think in relation to, although I accept the situation in Beauvale was different, there still is a live question here as to the question of what power was the tribunal acting under. So that's in response to the virus point. And the final point is just coming back to final point in relation to 29.3. If the AFS is filed within 21 days, then the Secretary of State can take part without anything further. If it's over 21 days, then there's a discretion, we say, to admit it, and if there's no AFS, there's still a discretion. Those are all permitted that's all the permitted reading within 29.3. And there is the power under Rule 7 in exercise of discretion for a failure to put in an AFS, which is lack of compliance with the rules. So there's that final individual case management discretion. But that doesn't allow, back to our primary point on Kumar, it doesn't allow for a broad-ranging generic position to be adopted. And the fact that Mr. Thomam accepts that it was an unusual arrangement that needed to be stopped, certainly in my submission suggests that this court should examine very carefully the power and operation of that guidance. I don't think I have anything further, but I'm very happy to address the court if there's any further questions you have.
Okay. No, there's nothing else. Thank you. Very well. Thank you both for your very clear submissions. We shall take time to reflect on our decision. Our judgments in draft will be circulated in the normal way for typographical corrections, not for any comment or purported correction of any substantive matters. You will be notified of the arrangements for hand down in due course. We do not anticipate the need for counsel's attendance at hand down. Thank you.
when we said we wanted to come back to court, actually I like my air-conditioned room with my with my. It's been quite nice.
But I think you do get much more out of it from.
Oh
seeing
yeah,
the one.
because the last case we did, like this one, they had loads of questions. It's really hard to do that on the screen.
Yeah.
People drop in, drop out. I couldn't agree more. Although, whoops, I need to remember about being in court. I don't know what it is.